And welcome to Russell Kennedy's Retirement Living webinar this afternoon, looking at national buyback regulatory trends. My name's Rosemary Southgate. I'm a principal here at Russell Kennedy and head up our property and development practice and have a specific expertise and experience working in the retirement living and aged care sector. Today's seminar is looking at national buybacks. There's quite a lot under review at the moment across a number of states. There's also a number of states who have reforms in progress where no doubt they'll be looking at issues around national buybacks. So we're really going to look at the regulatory trends across the country. And I hope you enjoy the seminar this afternoon. So before I get on to our topics in a bit more detail and talking about our panellists, I'll just talk about a couple of housekeeping issues. So firstly, if you can all keep yourselves on mute during the presentation. We have BD Tech support to assist you with any technical issues. So if you use the chat function, if you've got any tech issues, and they'll be able to assist you there. And also encourage you to use the chat function for any comments that you might have. Then there's also the Q&A function. So if you could use that to put in your specific questions related to the webinar, we encourage questions from you all, and we'll have some time at the end of the webinar to go through a live Q&A session. And then finally, there will be a post-webinar survey link sent to you at the end of the webinar. We're keen to get your feedback and hear about things that are of interest to you, so encourage you all to complete that at the end. And just note for yourselves that this webinar is being recorded. So now I'll just move on to introducing our speakers today. Firstly, we have Donna Rayner, who's a principal at Russell Kennedy and is specialist in the retirement living and aged care sector. Donna has worked in this sector for many years. She works across most of the states in this sector. She's also had experience working in-house at a large operator, so she brings that expertise and experience to the session. Then we have Rohan Harris, who's a principal who heads up our corporate and commercial team. He's based in Sydney, and Rohan really looks at the transactions and corporate side, particularly in the retirement living and aged care sector, and he heads up our Sydney office. And then we have Sylvia, Mansour and Lee B, who are lawyers in our property team and specialise in the retirement living and aged care sectors, and we'll be talking about some of the different issues across the states. So as I said at the start, the overview of our seminar this afternoon is looking at the current status of buyback requirements across the state jurisdictions, and we're really going to spend a bit more time on those states that actually have a regime in place and touch on those that haven't quite got that regime in place at the moment. So some states we won't be touching very much at all on what's happening there, because states like WA particularly, we know that they're under a significant reform process at the moment. But as happens, our regulators look across the states to see what's happening elsewhere. So we think these sort of issues will be relevant for you, and we'll be looking at some of the trends across the current reforms and the existing buyback regimes, how they link to things like resale obligations and the rights of residents to have control over the sale, where they might have an aged care rule that is helping to fund the resident moving into aged care. We're also going to look at the redevelopment requirements, because there are some states that have quite strict requirements around there, and they're similar issues for operators at the moment. And particularly at the moment, buybacks we think are particularly critical given where we're at with COVID and the various restrictions across the country, which are having an impact on resales for operators. And then we're going to finish up looking at what those issues mean for you in terms of liquidity, transactions and valuations. And then we'll have a live Q&A at the end. So on to the first state we're starting with. So I'm going to talk to you about Queensland and South Australia. These are really the first two states to implement some form of hard buyback regime. Queensland, the history there is that their amendments to the Act came into force at the end of 2017. Their requirement is that the exit entitlement is payable upon the earlier of the date set out in the contract, 14 days after settlement, and 18 months after the resident's right to reside in the unit is terminated. So the critical thing there is 18 months. And this applies to both lease licence villages as well as freehold villages. In relation to freehold villages, the requirement there is that an operator must actually enter into and settle the contract to buy back the unit by that 18-month date. So critical to be aware of there is the 18-month period. The trigger is the date of termination of the resident's right to reside. So it doesn't have anything to do with refurbishment or the unit being ready for sale. It's around termination of the resident's right to reside is the trigger. And the other important thing is that it's retrospective. So it applies to all contracts in force as at the end of 2017. And that means that it's been in operation for beyond the 18-month period. So we have seen the impact of those requirements in Queensland. And you would have seen there's been a bit of media around what's happened to a couple of villages, particularly at the end of last year, Settlers Lifestyle and Kalula Waters, where there's been, those villages have gone into administration, and reports that the trigger around that was due to that 18-month buyback regime. So the impact of it is well and truly being seen in Queensland at the moment. On to the next slide, where I just wanted to talk to you about how this links in with valuation, because I think this is important as to how the regulators are seeing buybacks and whether they're linking it into the right to sell and control over the resale or not. So just in Queensland, there's a requirement around valuations in any event. So within 30 days of termination, the operator and the resident have to agree on the value or get an independent valuation, and that valuation has to be updated every 3 months. So that's a requirement anyway. In the context of the buyback, that agreed value or valuation has to be current as at 14 days before the 18-month date. So you need to have an independent valuation. The resident also has the right to appoint an estate agent if the unit's not sold within 6 months of the termination date. So what is, I think, relevant in Queensland is that the buyback is not at all linked to the right of the resident to have any control over the sale. They seem to run separately. So the resident's right to appoint an agent, for example, only arises after 6 months. And that is different to the way some of the other states have looked at the link between buybacks and resales, which we'll get onto later on. So in Queensland, they do have a right to seek an extension of time. So an operator can apply to the tribunal for an extension of time if the operator is likely to suffer undue financial hardship, if the order would not be granted, and if it would not be unfair on the resident for that extension of time to be granted. So there is that right. At the moment, in Queensland, there is a review underway of this, and that's because there was a provision put into the Act at the time of those amendments which required an independent review within 2 years of the implementation of that 18-month buyback. So the government has appointed a four-person review panel to look at this, and they are due to report back to the Minister by the 30th of November this year. And they're specifically required under the terms of reference to look at the impact of the 18-month rule for existing residents, that is residents who are actually living in the village still, as well as outgoing residents who've left, as well as operators. And of interest, I think, is that in that terms of reference, they do particularly refer to villages where the resident is the owner, small local operators, and villages with operational issues. So that gives, I think, some indication of what the government is looking at in terms of that review. And the panel will be consulting with industry and resident groups in relation to that review. So it'll be interesting to see what comes out of that. And then just finally, we're also talking about where there's an obligation to fund aged care moves across the state. So in Queensland, there's no aged care rule, as we call it, which, as you'll see as we come to other states, there are in some other states. So that's Queensland. Moving on to South Australia, the timing of South Australia is similar to Queensland in that the amendments to their Act came into force on the 1st of January 2018. Similarly, in South Australia, the time frame is 18 months. So the obligation is to pay out the resident on the earlier of the date set out in the residence contract, and 18 months after the resident ceased to reside in the village. There is an odd, slightly unusual provision in South Australia that the resident can actually elect to remain in occupation until they're paid out their exit entitlement. And if they want to do that, they have to give notice to the operator of that. So that has an effect on the payout, because if the resident is still in occupation when it hits that 18 months, then that's extended out to 3 months after vacant possession. So a slight quirk there in South Australia. So the trigger, again, is vacant possession. Again, it's not linked to refurbishment of the unit or the unit being ready for sale. In South Australia, it applies to leasehold and licences. And again, it's retrospective. So it applies to all contracts from the 1st of January 2018. So again, we're well and truly into that 18-month period in South Australia. Again, looking at the links into valuation and sale rights. So in South Australia, there's no absolute requirement to have an agreed price and go through a valuation process. That only really kicks in if you hit the 18-month buyback. And in that case, then if the parties can't agree on what the current market value is of the resale price, the operator has to get an independent valuation. And then similar to Queensland, the resident doesn't have an absolute right to appoint an estate agent, but if the unit's not sold within 9 months, then they do have that right. So again, it's not linked to any control of the resident in the resale process in South Australia. There is another provision in South Australia which specifically permits a resident to elect to defer payment beyond the 18 months. And if they want to do that, they have to give at least 3 months prior notice to the operator. So at the 15-month mark, they need to give notice to the operator. And that's really if they decide that they think they'll get a better price on resale. If they wait out the 18 months, they can elect to do that. South Australia also has a similar extension of time right to Queensland, right to apply to the tribunal. There they talk about special circumstances existing, and that is, again, grounds of financial hardship, provided that the operator has taken reasonable steps to comply with the buyback requirement. Then in South Australia, there is an aged care rule, and I'll just hand over to Lee now, who will just talk about the aged care rule in South Australia.
Perfect, great. Thanks, Rosemary. So in comparison to Queensland that does not have an aged care rule, as Rosemary has noted, South Australia does. And I will be providing a summary in relation to the aged care rule currently in place in South Australia, and the process by which a resident can make an application to the operator to have the operator make the aged care payments to the aged care provider on the resident's behalf. So the section in the Retirement Villages Act that deals with this is Section 30, and it contains the provisions in relation to a resident leaving a village to move into aged care. So an application has to be made by the resident to the operator within 60 days of either being approved to enter into aged care facility or ceasing to reside in the village. Ceasing to reside refers to the resident providing vacant possession of the residence back to the owner or operator. However, before an application can be made, a resident has to meet the resident eligibility requirements in order to make an application to the operator. The eligibility requirements that a resident has to meet are the following. So firstly, they need to be approved to enter into a residential aged care facility. Secondly, chooses to pay a refundable accommodation deposit. Thirdly, they don't have readily accessible funds to make the payment, to make the deposit themselves, as would cause undue hardship on their personal circumstances. And they're entitled to payment of an exit entitlement. Upon receiving an application, if an operator is not satisfied with the application made by the resident, then they can request a resident to provide further evidence to show that they do not have the financial circumstances to fund the deposit. So an evidence that they can request is a Centrelink income and assets assessment to assist with the assessment of the resident's eligibility to seek payment from the operator. It is important to note, and something that I would like to note, that an operator must make payment within 30 days after receiving a properly made application. You'll know that in the Act, it does refer to a properly made application. So if in the event an operator were to receive an application that they're not satisfied with, it is important to request the further evidence before this 30 days is up. This is because if an operator does not comply with Section 30 of the Act, they will be guilty of an offence. And under the Act, the maximum penalty is a fine of $5,000 and an expiation fee of $315. Similar to Victoria, an operator is to continue making payments until the earlier of the payments have reached 85% of the operator's reasonable estimate of the resident's exit entitlement, or the resident's exit entitlement is paid to the resident pursuant to one of the events that Rosemary had referred to in her previous slide in relation to when an exit entitlement is to be paid back to the resident. Similar to Victoria aged care rule, which is what I'll be discussing further in my presentation, at the time when the resident's exit entitlement is to be paid to the resident, the payments made to the aged care facility may be deducted from the resident's exit entitlement at the date when it's to be paid back to them. So that's my brief summary of the South Australian aged care rule. I will now pass over the Zoom microphone over to my colleague, Sylvia.
Hi everyone, I'm Sylvia and I'll be giving an overview on New South Wales and the ACT. So the legislation around exit entitlements in New South Wales and the ACT are aligned with each other. So currently in both states, for residents who are registered interest holders, unless the contract provides for earlier payment, the operator must pay the resident their exit entitlement within 14 days of the earliest of the date the operator receives full payment under a residence contract, the date the operator enters into a village contract, the date the operator enters into a residential tenancy agreement, the date in which a person takes up residence in the premises with the consent of the operator, or if the operator buys the premises from the former occupant, the date on which the operator completes the purchase. Whereas for non-registered interest holders, the retirement village operator must pay the resident their exit entitlement within a maximum period of 6 months after the resident provides vacant possession of the premises. Okay, I'll just have the next slide, please. Thank you. So there's a distinction between registered interest holders and non-registered interest holders under the Act. I won't go into too much detail now, but there's a summary on the slides there. Okay, can I have the next slide, please? Okay, so the reforms. For those of you who have heard me speak before, there are New South Wales reforms which were announced on the 24th of June this year and which will only affect registered interest holders. If a unit remains unsold after 6 months in metropolitan areas or 12 months in regional New South Wales, the residents will be eligible to receive their exit entitlements if they believe the village operator has not taken reasonable steps to facilitate a sale. These reforms will only apply to registered interest holders. In relation to strata, freehold, company and trust properties, whilst the government's media release does not specify that these will be excluded from the new reforms, we understand and note that the government has advised the Property Council that they will be excluded, but there's still some uncertainty around that. There will be no change to non-registered interest holders' rights. Although something to note is currently for non-registered interest holders, the timing is from vacant possession. However, under the reforms, the trigger point for the clocks to start ticking is the actual handing over of the keys for the property to be marketed. So after it has been prepared for sale. So there is a difference there in terms of when the clock starts ticking. So the safety net of these new reforms will require operators to buy back the unit from the resident. And this aims to rectify the current problem where residents may wait for extended periods of time to receive their exit entitlements, which can cause a financial and personal burden on the resident. Under these reforms, a registered interest holder will have the right to apply to the Department of Customer Service for an order requiring the operator to pay an exit entitlement if, in their opinion, the operator has unreasonably delayed the sale of the property. And then in terms of the capital gain, that would be determined either by the parties agreeing to a value for the property or by an independent property valuer if they cannot agree. And if there's a dispute, mediation can occur and the parties can also access the tribunal for a final decision. So regarding the ACT, there are no proposed changes at the moment, but based on the adoption of other New South Wales amendments, it would not be surprising if the ACT adopts similar buyback regime. And if they do, we will update you on that. Okay. Can I have the next slide? Yeah. So here is just a graph which summarizes the current and reformed exit entitlement timing for both registered and non-registered interest holders. So the blue shows where New South Wales and the ACT are currently at, and then the yellow shows where New South Wales will be after the reforms and with ACT possibly following them. Okay, thank you. I will now hand you over to Donna.
Thank you, Sylvia. My name's Donna, and I'm just going to touch very briefly on the aged care rule for New South Wales and the ACT. It's very simple at the moment. There is no rule for either New South Wales or the ACT, but that's about to change. So Sylvia's already mentioned that we've had a media release about reforms. Well, this is another reform that's going to be implemented, we expect by the end of this year. And basically, the aged care issue was raised in the discussion, in the Rayner report originally as an emerging issue that was developing within the New South Wales retirement village industry. And as a consequence, the government then released their discussion paper towards the end of last year, and then requested submissions from operators and residents. And then, of course, they've just made this announcement that, yes, they are going to be adopting an aged care rule along with changes to the exit entitlement or buyback timeframes. And they're also going to implement a recurrent charge cap as well. Whilst Sylvia's already noted that, that the proposed changes have not yet been released, we anticipate that they're actually going to follow in terms of the aged care rule along the South Australian lines. And I think this is pretty well supported by what's on the Department of Fair Trading's website at the moment, which seems to support this view. And that's that residents would be entitled to request an operator to an advance up to 85% of the residents' exit entitlements, which would be paid as DAPs to the aged care provider on behalf of the resident. Again, we're not anticipating that the aged care rule will affect strata title units or company title or trust ownership of units. So I think if you're looking at the South Australia, I think this is a really good guide in terms of the aged care rule that's likely to come into force in New South Wales. And like Sylvia's already noted about the exit entitlement regime for ACT, whilst the ACT legislation hasn't been reviewed for some time, it has picked up along the way various New South Wales legislative changes. And so again, we expect that the ACT will pick up the aged care rule as well down the track. And that's all I really wanted to say about the aged care rule for New South Wales and ACT. And I'm going to hand back over to Lee to discuss the rules in Victoria.
Great, thank you, Donna. So back to me. I will now be discussing the current state of play in Victoria in relation to buybacks and the aged care rule. So just like all the other jurisdictions, there are events that trigger repayment of a resident's refundable ingoing contribution. So in relation to freehold title, so owner residence as is referred to under the Act, the resident is entitled to a refund of their ingoing contribution on either 14 days after which settlement has occurred on the sale of the premises, or if the vendor and the purchaser has agreed that the purchaser can enter into the premises before settlement has occurred on the sale, then 14 days after the resident moves in, then the resident is entitled to a refund of their ingoing contribution on that day. Great, if I could just pop next to the next slide. Great, so in relation to leasehold premises, so non-owner residence as noted on the slide, there is no specific requirement that a buyback contract is entered into, and there is no absolute compulsory buyback regime in Victoria. So what do I mean when I say no absolute? I'm referring to the exception as outlined in the Retirement Village regulations, which I will discuss further on during my presentation. So for non-owner residents, the resident is entitled to a refund of their ingoing contribution on the earlier of one of the following events occurring. So as noted on the slide, 14 days after which the owner receives the new refundable ingoing contribution from a new resident, and when the former owner has also delivered vacant possession, or 14 days after the day on which a new resident moves into the premises, or 6 months after the resident has delivered vacant possession of the premises. So this exception that I was referring to is in reference to working around this 6-month trigger event as noted on the slide. So pursuant to Regulation 6, if a resident contract includes Schedule 1 clauses, so under the regulation that means clauses are referred to the sale process. So in relation to a resident's right to appoint agent, a right to set a sale price, and also to be kept informed as to the sale process. Then if those clauses are included in a resident's contract, then the resident's entitlement to refund of their ingoing contribution is different, in that the resident is entitled to recover their ingoing contribution on the earlier of one of the following events occurring, which includes 14 days after which the owner has received a new refundable ingoing contribution from a new resident that is equal to or more than the amount owed to the non-owner resident, and the vacant position has been provided, or 14 days after the day on a new resident moving into the premises. So you'll note that by inserting these clauses, it removes that 6-month trigger event. 95% of villages in Victoria currently take up this method of including those relevant clauses in the residents' contracts in order to remove or avoid that repayment being triggered after 6 months once the resident has provided vacant possession. Great. So if I could just move on to the next slide. So that was a summary of the current buyback regime in Victoria. Now I'll be discussing the current aged care rule in Victoria. So similar to other jurisdictions, the aged care rule in Victoria only relates to leasehold or licensed premises, so not freehold titles. Similar to that of South Australia, a resident has to satisfy the requirements of being an entitled person under the Act in order to provide a notice to the retirement village owner to make payments to the aged care facility on the resident's behalf. So, similar to South Australia, there are these eligibility requirements. In order to be an entitled person under Victoria, it means that all or part of the resident's ingoing contribution is refundable. they are not yet entitled to receive their refundable ingoing contribution. They have been accepted into an aged care facility, and they're required to make an accommodation payment to the aged care provider. A key difference between South Australia and Victoria eligibility requirements is that in Victoria, the resident is not required to show that they do not have readily accessible funds to pay the aged care costs. So this means that upon being provided a notice by the resident, the owner will be required to fund either the daily accommodation payments or refundable accommodation deposit to the aged care provider on the resident's behalf. And there are no provisions in the Act where they can seek further information from the resident in relation to obtaining evidence to their Centrelink income and assets, in relation to confirm their financial situation. So depending on when the residence contract is entered into, the retirement village owner has different aged care payment obligations. So in relation to residence contracts entered into before 1st of August 2006, there is no obligation upon the village owner or operator to make any aged care payments on behalf of the resident. But residence contracts entered into between 1st of August 2006 and 29th of July 2017, if a resident chooses to pay a refundable accommodation deposit, then upon the owner receiving a notice by the resident, the owner is to pay the deposit no later than 6 months after the resident enters into the aged care facility. But if in the event the resident chooses to pay the daily accommodation payments, the DAPs, to fund their aged care, then upon the owner receiving a notice as to this, then the owner is to pay the daily accommodation payments as and when they fall due. So now moving on to residence contracts entered into after the 30th of July 2017, then if a resident notifies the owner that they have elected to make the aged care costs by way of daily accommodation payments, so not a refundable deposit, then the owner must pay to the aged care provider the daily accommodation payments as and when they fall due. So again, very similar to South Australia, there is a cap on how much the retirement village operator is required to pay, which is no more than 85% of the operator's reasonable estimate of the unpaid refundable ingoing contribution. So you're probably wondering, how do I come to this reasonable estimate? So how retirement village owners are to come to this reasonable estimate pursuant to the Act, it's calculated in accordance with the current market value of the premises. So if in the event the resident disagrees with the valuation that the owner has come to, then upon the resident and the owner agreeing, they can appoint a valuer that both are happy with. But if in the event there's still a disagreement as to the chosen valuer, then a valuer is to be appointed by the Australian Property Institute. Another thing to note in relation to appointing a valuer is that the costs are to be split equally between the resident and the owner. So if in the event the owner were to calculate that complying with their requirements to pay the refundable accommodation deposit will cause undue hardship on their financial circumstances, so liquidity is something that my colleague Rohan will be touching on later on in this presentation, then the owner may apply to VCAT to request that daily accommodation payments will be made in lieu of payment of a refundable accommodation deposit. Again, similar to South Australia, at the time an exit entitlement becomes payable, any aged care payments made by the owner will be deducted from the resident's exit entitlement at the time that it is to be paid back to them. Great, so that's my summary on Victoria. I will now hand over the presentation over to my colleague Donna, who will now discuss the provisions in Tasmania.
Thank you, Lee. So I'm briefly just going to provide an overview of the buyback or exit entitlement regime in Tasmania, as well as the aged care rule. It's going to be fairly quick and punchy. So in Tasmania, under Section 12, unless the contract provides for an earlier date, where the resident dies or vacates or gives a notice of termination, then the contract terminates on the earlier of the dates that are specified on the screen, which is 6 months after death, 6 months after notice of termination, or 30 days after the resale or reoccupation of the unit. The other thing to note as well is that the operator also has an obligation in terms of that time frame to take all reasonable steps to resell or relet the unit. And a failure to comply in Tasmania could result in quite a substantial penalty. In the Act, it's 350 penalty units, which at the moment is worth about $172. So that would equate to a potential fine of $55,000 for non-compliance with those provisions. However, Tasmania has a serious financial hardship provision, so that would enable an operator to make an application to the Director of Consumer Affairs where they would suffer financial hardship if they needed to make the payment within the time frame specified in Section 12 of the Act, which I've just covered. If I could have the next slide, please. And then moving on to aged care, what I think is really interesting is that Tasmania's Act has not been reviewed for many, many years and came into effect in around 2005, beginning of 2005, and they actually had an aged care rule back then. So I think that's really interesting. It's a fairly simple rule, but it's a fairly strict time frame in terms of payment. And so it's very similar to the other jurisdictions in terms of the resident needing to move to aged care. It's similar to South Australia in terms of the resident not having ready access to funds. And so whilst the Act's silent in having a right to request that information, I think it's implied under the legislation that it would be reasonable for the operator to request this information. And obviously the resident has to have been accepted into aged care. To enable a resident to access these monies from the operator, they've got to make the application within 10 business days after they leave the village. And once they notify or make the request to the operator needs to make the payment. And interestingly, one distinction between Tassie, Victoria, South Australia and the proposed New South Wales changes is that the payment in Tasmania is to be made to the resident. This was actually something that used to be in place in Victoria, which thankfully it's been tightened up in terms of not making the payment to the resident, but actually paying it to the approved provider, which I think will probably happen. And in practice, I'd like to think that that's what operators are doing rather than paying it to the resident themselves, because then you can be guaranteed that the money is actually going to pay for aged care. And in the legislation for Tasmania, there is no cap in relation to the payment. And so in that regard, my view is that you would have to pay the lesser of what their estimated exit entitlement is and what is due to the aged care provider. Again, it doesn't distinguish between RADs and DAPs in Tasmania, so I think the resident could make the request for either. And once again, in Tassie, there is a serious financial hardship section as well. So if the operator was going to suffer serious financial hardship, they could seek an extension on the time frame for repayment. But in terms of paying any difference, so the difference between, say, a RAD or the DAPs that the operator may have advanced on behalf of the resident, there basically isn't any valuation process or anything like that, but payment has to be made in terms of the resident's entitlements under Section 12. So in that regard, that's the maximum 6-month sort of time frame for repayment after termination. So it's a pretty tight time frame in Tassie, but the rules are there. I'm not aware of any applications for serious financial hardship that have been made under either provision in Tasmania. And then if I could have the next slide, please. So just in summary, what do these trends mean for the industry? I think that what's important to note is that where you've got compulsory buybacks in one jurisdiction, I think you can see some common trends. It seems to be filtering down, particularly along the eastern seaboard. There's already a form of buyback in each jurisdiction in any event in terms of exit entitlement timeframes. But these are being re-looked at, and also the transition to aged care. This is a critical issue for residents, and it's come out in the two inquiries into the retirement village industry in both New South Wales and Victoria. Victoria already had an aged care rule prior to the proposed changes to New South Wales and also prior to the changes in South Australia. The other thing I think is really important to note is where we've got buyback regimes, and so there's tight timeframes in terms of having either resold the unit within, for example, the 18-month timeframe for Queensland or South Australia. Having really good marketing processes will be critical in terms of mitigating the risk to operators from a liquidity perspective, and I think we've seen that that's been pretty critical in Queensland. So it'll be interesting to see how that plays out in terms of New South Wales, which has slightly shorter time frames, but I think the trigger points will be interesting to note as well in New South Wales, which really came about with a lot of pushback from operators and strong lobbying from the Property Council in terms of having the unit ready for marketing as opposed to vacant possession. So good marketing processes will be critical in terms of mitigating that risk. And I think it's also important for operators to consider their liquidity requirements. So with buyback regimes coming into effect or already in effect in multiple jurisdictions, and also with aged care rules in multiple jurisdictions, operators will need to have ready access to funds to be able to fund payments either to residents or an aged care provider. And then and that's what I'd like to summarise in terms of where we're at so far. Then I'd like to hand back over to Rosemary, and we're going to talk about some redevelopment requirements.
So we're just going to really briefly touch on this because we're starting to run a bit short of time, but we thought that really there's a growing trend as well around obligations around redevelopment of old stock in existing villages. So we thought it was worth touching on this. So I think the most stringent regime again is in Queensland. So there's an obligation there for an operator to have a redevelopment plan, and it has to be in the prescribed form. This is a redevelopment which they call a running redevelopment, as in you'll have residents still in occupation at the village and you're operating the village while you are redeveloping. In short, the plan has to be approved either by 75% of the residents, so by a special resolution, or by the chief executive. If you go to the chief executive, then residents are entitled to make submissions to the chief executive, which they have to take into account. So it's quite a strict regime there. And there's a right of appeal to the tribunal around the decision of the chief executive. And then the operator is required to only implement that approved redevelopment plan. So yeah, Queensland is quite strict in its requirements around that redevelopment of old stock. Briefly onto SA, the obligation there is that you have to have a meeting with residents before any redevelopment is commenced. There's no approval required, but you need to present a plan to the residents and answer their reasonable questions. So not such a stringent requirement there. And then on to the next slide. Thank you for Donna to just finish off on New South Wales.
Thanks, Rosemary. So I'm just briefly going to touch on New South Wales. I'm really not going to mention ACT other than to say that really the ACT mirrors the provisions in New South Wales. So in New South Wales, there's a section 136 of the Retirement Villages Act, which enables an operator to seek an order from NCAT in New South Wales to terminate a resident's contract if they intend to carry out substantial works that would require vacant possession of the premises, or the land on which the village is situated is going to be used for a purpose other than a retirement village. But what's important to note is that before the operator can make the application, they must give residents a 12-month notice. That notice is in a prescribed form. The prescribed form's in the regulations, and it's a little bit confusing because there's section 131 actually deals with the requirement to serve a prescribed form of notice, but the regulations deal with the forms of notice that an operator can apply for in terms of termination, and it just pops them all into the one form just to make things, I think they think simpler, but it's caused some confusion, in particular in terms of service of that particular notice, because effectively you need to serve 2 notices. So I've noted a case there, and I don't propose, just due to time constraints, going through that. But if you get a chance, have a look at that case. It gives some really good guidance on what to do in terms of getting a successful order from the tribunal to terminate a residence contract where you're redeveloping. And it also talks about the anomalies in terms of the prescribed forms of notice that you need to give to residents. The other triggers that you need to be aware of is that you can't actually make the application unless you've got all your ducks in a row, so to speak. So what I mean there is that you've given the notice, you've got your development consent and approvals. And again, the basic case actually touched on, well, what does that mean by required development consents? The basic case actually was a staged development, and it was a complete redevelopment of the whole site. And what they basically had at the time that they made the application was just a demolition, consent for demolition. The residents obviously objected to that and said that it didn't comply with the Act. The tribunal found differently. And so, again, that case is really good guidance. Other than that, the only other point is that residents need to be given alternative accommodation or made an offer of alternative accommodation, and that accommodation has to be the same value, not require a greater financial outlay, and it's got to be reasonably acceptable. That's all I wanted to say about New South Wales in terms of redevelopment. And so I suppose what the important things to note there is that we've got multiple jurisdictions which are considering redevelopment and the right to terminate for redevelopment. And I think that's important in terms of those jurisdictions that don't actually have rights to terminate for redevelopment purposes. The basic case, I think, really gives some good guidance in terms of how you should really approach a redevelopment of a site where you don't have statutory rights to terminate, just to give some guidance in terms of approaching and communicating with residents. I think the other thing that will be important is in terms of those jurisdictions that already have these provisions, looking at whether that actually may be the right thing or the financial right thing to be doing in terms of the compliance requirements. So Queensland, for example, is very stringent. Is that really going to be worthwhile going through that path to do a redevelopment? Perhaps it may be better to actually consider a resale of the site. And then I suppose in terms of where there is no statutory provisions, I think it's really important to note that you can't just terminate a residence contract. So you can actually redevelop, but you need to do that with agreement between the parties. And that can turn pretty bad if it's done very badly, but can be done if it's done well. And then that probably finishes it for me, and I'll hand over to Rohan, who can really talk about some of the issues that we've already discussed in terms of valuations and liquidity on operators. Thank you.
Thanks, Donna. Hi, everyone. So I haven't met you. My name's Rohan Harris. I work in the corporate transactions team out of the Sydney office. And I wanted to give a bit of perspective around issues of valuations, transactions, liquidity. Basically, these rules are complex, and if you're a multi-site, multi-state operator trying to come to terms with all these rules, there's a lot to take in. But I think, if I'm a CEO or director of a retirement village operator, then it really boils down to the question of liquidity and do we have the funds available to meet these commitments as and when they come up? And of course, the financial resources can come from a number of sources. Either income from new residents, that's the ideal scenario. So if you've got a demand for accommodation in your village and you've got people who want to come in and pay a price, then that's obviously where the money will come from. But if you're not in that position, then you're going to need to be looking at other sources of income to meet these commitments, and that typically revolves around additional equity from owners. That's always that's an option potentially for private operators, but not necessarily for not-for-profit operators, of which there are many. So this presents real challenges. And also looking at availability of debt, which again is not necessarily the silver bullet, particularly in the current market, where my experience is that banks and valuers are paying a very close attention to the state of the industry and values in the industry, and there are things changing there which make availability of debt somewhat restricted. On the next slide, there's a bit of a checklist here that I've put together for boards. Those of you who sat in for our last webinar for New South Wales operators on the buyback rules in New South Wales may have seen this, but for the non-New South Wales people, this is a bit of a checklist that I've come up with for board members and for CEOs or executives of retirement living operators to sort of use as a guide. And I think the liquidity question boils down to, you know, do we have the right offering or the product? Is this something that is attractive for the market at the moment? Because obviously that is the sort of thing that's going to drive sales and demand. Second point is around, you know, how can we improve our sales processes? And this is particularly important in New South Wales, for example, where where it's not a hard and fast rule, and there is some ability to have a proper process and to improve sales and improve the liquidity position. I think at the moment, obviously there's been a lot of very sad cases in the aged care sector, particularly in Victoria, around COVID infections. It's not beyond the realms of possibility that something like that could affect a retirement village, particularly a retirement village where the living arrangements are, you know, in sort of multi-story type developments. I think there needs to be some stress testing around that sort of scenario. If you had an unusual number of exits from a retirement village for people who are infected and perhaps need to go to hospital or unfortunately pass away, these are the sorts of things that we should be testing. Also, other things around expense controls, access to additional equity, debt facilities, looking at when they're up for renewal. Ultimately, for many operators, I think this is going to come down to a question of whether it's actually time to sell. And there are many operators that we're aware of that are certainly doing this, but also others who are looking to purchase and take the opportunities for when villages come up for acquisition, and to derive benefits from economies of scale. So there are a few liquidity and governance issues that arise, in my view, from these sorts of from the buyback rules. So back to.
Thanks, Rohan. Sorry, I was answering questions as well, and then trying to unmute. So I suppose just in terms of next steps, just to finish up as a catch-all kind of thing, what you can do now. I think the first critical thing that you really need to do is review your sales processes to make sure that you're really selling units as quickly as you possibly can, particularly in those jurisdictions where you have pretty tight timeframes in terms of buyback regimes, and just generally a review of these processes in any event anyway. The other thing that Rowan's already touched on is in terms of review what your current offering is, and is it sustainable? Is this what residents are looking for now? Is it going to be sustainable in the future? Or is it going to have, or could it result in triggering buybacks and you being left with stock and falling into a liquidity issue? Again, I think Rowan's already touched on this as well. You really need to implement liquidity checklists. So checking in terms of how many units have you got vacant? what's the timeframes in which it's taking to sell units, and look at the possible implications that that could have on your operations in terms of liquidity. Are you going to have to raise funds? Are you going to be able to raise funds? Those types of things are critical, and you can look at those things now, particularly in light of what's already in place and what's proposed, particularly in New South Wales. And now that's probably our steps for the time being. If you have any, we've got a few Q&As that have come through, and I know that Rosemary is going to answer some of those live, and I'll jump back on and try and answer the couple that I was doing as well. Thank you.
So thanks very much, everyone. I know we've bombarded you a bit with some information there, but we thought it was useful for you to hear a summary of what's happening across the country, and these slides will be sent to you all, so you will have the detail of those matters there to refer to afterwards. I just wanted to confirm what Donna said at the end then. I think that really your sales processes are the critical thing to come out of this, particularly in those states where it is linked to showing that you've taken all reasonable steps or acted reasonably around the sales process. It's really important to make sure that you and your teams are really on top of that. So look, now there's a few questions that have come through. We've answered some of them, but I think a few would be useful to answer live. So there's a couple of questions around the South Australian aged care rule, and the question there around, is it a RAD that has to be paid, or is it actually a DAP? So Lee, I might throw that one to you if you can answer that one.
Yeah, no worries. So in relation to the South Australian aged care rule, one of the eligibility requirements is that the resident elects to pay a refundable accommodation deposit. But in terms of the provisions, it does refer to the owner making the daily accommodation payments up to that 85% cap. So yes,
yeah.
it does.
Yeah, so it's a little bit confusing in that it refers to the RAD, but it's actually the DAP
that
you're paying there.
Yeah, that's right.
There's another question here around the New South Wales reform. So question for you, Sylvia. Is the 6-month buyback obligation on the resident to prove the operator has unreasonably delayed the sale of the property? Does this mean if the operator is doing all it can reasonably do to sell the property, then the 6-month buyback obligation does not apply?
Yes, so as it currently stands, that is our understanding. However, as the reforms haven't been passed yet, and it's quite, saying that they haven't reasonably delayed the sales, quite ambiguous. So we'll wait until the reforms are passed to get further clarity on that. But as it currently stands, yes. So if a unit remains unsold after 6 months in metropolitan areas or 12 months in regional New South Wales, the residents are only eligible for their exit entitlements if the operator has unreasonably delayed the sale.
Yeah, so I think what Sylvia was just saying is the devil will be in the detail as what does that actually mean? But I don't think that will get you around making a repayment. I think the legislation is likely to have a process that you're going to have to follow to facilitate paying back the resident within a reasonable time frame.
Okay, another question about the aged care rule, and that is, are there any clawback provisions in favour of the operator in any of those jurisdictions which have that aged care rule if the payment is overstated? In other words, if you end up paying more than ultimately you resell the unit for, is there a clawback provision in the legislation? Donna, I throw that one to you.
Thanks, Rosemary. There isn't any clawback provisions as such, particularly Victoria, there's no clawback position. Same for South Australia, as far as I'm aware, with the 85% cap. Of course, New South Wales, we don't know the detail yet, but the whole rationale behind this 85% cap is to try and factor in that type of, readjustment in terms of the price that's been assessed as being the value of the unit at that point in time. So I know that's uncertain at the moment in terms of COVID, because what's been estimated may not be reasonable in the circumstances. But in that situation, the resident couldn't be unjustly enriched either. So I think there would be a clawback availability, and obviously, you know, it would be a debt to the operator.
And I suppose the other thing is it's important to put that in your contract too, is to make sure you've got that clawback right in your resident contracts in those circumstances. I think we've got time for one last question. So just for those of you where we haven't quite got to your questions, we will be sending through some responses after this. So I might just go to the one last question, which is around a question about what does vacant possession mean. So in those states where vacant possession is the determinative factor, this is around the buyback, I don't think any state actually has a definition in the legislation of what vacant possession is. But the common law meaning of vacant possession is that the resident has vacated, removed all of their possessions and handed back the keys to the operator. So that means it's not that it's in a good condition for sale or refurbished, it's that they've actually vacated.
And actually, just in New South Wales, they I think Sylvia touched on it as well. They do have a definition for permanent vacation.
Yeah.
But I know that was talked about in terms of their proposed changes. They did want to talk about that being calculated from the date that the unit's available for marketing. So a distinction, but again, you know, as Rosemary said, it'll depend upon the detail, I think.
Mm.
Okay, well that brings us to the end of our webinar. Thank you everyone for joining us this afternoon. Again, can I just remind you to take the time to complete the feedback for us, and included in that is suggestions you might have about other topics that you'd like to hear from us on. We're always keen to hear what's of interest to you out there in the industry. As I said, there'll be some Q&A follow-up for those few that we didn't quite get to. We'll be coming back to you on that. And look, we're here to support you through, I know, what's been a pretty difficult time, particularly for operators in Victoria and New South Wales. And we look forward to working with you all through this period and see you all on the other side. So thanks very much.
Thank you.